Thank you, everybody. Thank you to all of our friends tuned in from all over the world. Thank you for joining us in today's immigration conversation with the amazing one and only attorney Sharif Silmi. Hi, Sharif.
Hi, Mary. How are you doing? Thank you. I really appreciate the opportunity to have this conversation.
Yes, me as well, and many of our friends who are tuned in. Some of the people we just spoke to today and in the last weeks, they're tuned in. They're very, very excited. So I think you can take it away, especially with the updates, especially when it comes to what they can expect when it comes to EB-1A, most especially, Sharif.
Sure. Yeah, I did want to mention that, essentially there is a new update with regard to some of the limits and how that impacts the overall scenario. So basically, we have now reached the point in the fiscal year that the EB-1 category is, utilized all the available visas, right?
Yeah.
So I want to go ahead and share that here, um, which I am having a bit. Oh, there we go. So here we go, where the annual limit in the EB-1 category has been reached. So the State Department essentially announced that of all of the available visas for fiscal year 2024, they have allocated all of the availability of EB-1. And some people might see this as sort of like a warning, or like, this, what does this mean for me? Does it mean that my case is not going to be decided or determined? And what I want to do is I just want to give some clarity on this point. And you do not have to worry at all if you are seeking an EB-1A as it relates to this particular update. Essentially, what this means is that those cases in the EB-1 category, and this applies to EB-1A, EB-1B, and EB-1C, all of those categories, that is EB-1A, extraordinary ability, EB-1B, outstanding researcher and professor, EB-1C, multinational executive and manager, those of the highest employment-based category have all been utilized for the present fiscal year. So as of August 27th, there are no more availability for EB-1 visas. That means that USCIS, upon completing the adjustment of status process for an individual who has an already approved EB-1, or EB-1A, B, or C petition, would not be able to allocate the adjustment of status. There's no visa number to be allocated to that particular case for the remainder of the fiscal year. Now, you have to understand the fiscal year will end on September 30th. So as of October 1st, that will be renewed, and they're going to be allocated at that time. So you will not see a situation where one who has an EB-1 category approval will have an approved adjustment of status between now and October 1st. However, USCIS is going to continue to process those cases. And then starting October 1st, those visa allocations will be renewed and done. The reason why I think this is actually a good sign is because what it tells us is the government has their act together in terms of distributing all the availability of visas. There have been years in the past where, and this is true of Republican and Democratic administrations, where all the visas available were not utilized, although there were people available and completing all of the process and requirements. So they were just basically, due to bureaucratic delays and inefficiencies, there were circumstances where the availability of visas were just lost or wasted. Whereas here, what we're seeing is it was very well allocated over the span of the year, and basically 1 month prior to the end of the fiscal year, there's no more availability. And that, starting October 1st, upon the start of the new fiscal year, those visas will be, available once again. So that is sort of the situation right now. And I think that, for the most part, we are in a pretty good state as it relates to the situation. So one other data point I did want to share with folks And I'm just going to relay the numbers. And this is through first quarter of 2024 and first quarter 2024 fiscal year. So there's a lot of talk out there about, increased like
Mhm.
uh, approval of EB-1A. That,
Mhm.
I heard so and so got approved. I actually don't think that's the case, or the data has not indicated that that's the case.
Yeah.
There's a consistency in the numbers. So I think there's a increase in maybe marketing by folks, particularly non-attorneys, who
Mhm.
are sort of claiming certain things, but I don't see, and we can move off from the annual limit reach. I don't see actual situation where there are an increase in approvals according to the data that's shared by USCIS. So, for example, under the Aliens with Extraordinary Ability 2024 Q1, there were 395 Indian nationals who
Mhm.
were approved for EB-1A. That's E11 category, aliens with extraordinary ability. So 395 approved. So I think that, basically we're not seeing a situation where there's an increase in approval. I also see that there were essentially um, so there's 1,400 cases that were submitted, and 395 or so were approved. So I don't necessarily see within, any kind of database approach that there. In fact, that's a very low approval rating. And we know what our internal numbers are. They're very, very strong. They've been consistently strong. But I do see that externally there is a very high level of denial in the EB-1 category, particularly for Indian nationals. So that it's kind of hard to figure out the exact data because they don't separate approval denial by, well, they separate approval by category, but you don't necessarily know where the denied cases are in relation to the full petitions. But
Mhm.
when you look at the overall numbers, the sort of like correlation between the total petition and approval is much better. So I think that we do see a lower number of cases approved among Indian national than non-Indian national, and we do see a lower approval among Chinese than non-Chinese. So the non-India China cases are definitely approved at a higher rate, and I think that it's probably because they have an option of filing in EB2 national interest waiver and acquiring a green card in a relatively reasonable period of time. Whereas folks who are, from India, China, they don't really have that luxury. So they're, more likely to kind of consider, alternative routes. But just so you guys understand the data, this is an entire quarter.
Mhm.
USCIS is reporting 395 approvals in an entire quarter in the entire United States. So, there are a lot of claims and, things that people say, but relying on actual data from the government, I would say, is a better approach than to, listen to certain, I think, folks who are, talking or explaining what is out there when it doesn't really match or correspond to reality.
Yeah, and I'm glad that you shared that, Sharif, because like well, a lot of the people that I spoke with in the last week, they would keep asking me, oh, I heard like I mean, like we're glad that many people recommend us, right? But in general, I think they get it through the forums or hearsay. They say that the high rate of approvals is because of the government, and I have to tell them, no, it's not just because the government just wants to approve you, right? There's like the effort, right, the expertise that we put in. It's not just because, oh, we filed now and everybody gets approved. That's not the way that it works. Although people really do have that feeling that, oh, just because we're filing in this administration, we have to file within this administration, and we have to file it now if in case there's an administration change that in the next year.
Yeah, I mean, it's nice to deal with what you know versus what you don't know, but I think, and I guess generally, I would say that where there is a situation of being able to file with the process that you understand, it does work well. But I just want to give you another data point, and that is approval. And so basically this is 2017, right? So 2017, you had, and I'm looking at EB-1A. So you have, okay, 32,000 applications. And
Sorry, that's
yes, so so again, we don't really know. So 17 and 8 is 20. So we don't know exactly which of these are, approved and denied, like in the particular, like body of cases. But essentially, you have 9,000 cases approved out of 32,000 that were applied, and this is 2017, right? In so 8,000, sorry, I'm going to give you exact numbers. 8,447 out of 32,000, right? That's EB-1A. Now 2023, you have 9,443 out of 37,275. So you have about 5,000 more applications, and you have roughly 1,000 more. So that's a lower approval percentage in 2023 than it was in 2016 or 17. So basically, you have a better approval rating in EB-1A during the Trump administration than during the Biden administration. So that's just data and fact, right? Data and fact. Now, India, for example, let's see. So 2017, you had, out of 9,466 applications, you had 1,392 approval. And then 2023, you had 11,974 application and 1,903 approval. So I think that's slightly better, maybe. I didn't do the math. So in all fairness, I'm sure the STEM mathematicians out there can figure this out better than I can. But basically, it is 11,974 application of all the EB-1 application. 11,974 Indian application, 1,903 were approved. For China, it was, so China, you have a lot of EB-1C, but you also have a lot of EB-1A. Actually, they have much more. They had out of so 2023, and their approval rating was much higher also. So they had about 3,755 approval out of 9,382 application. So, again, I know there's a lot of forms out there that are specific to India-based clients, but you got to understand your approval rating is basically less than half of Chinese nationals. So maybe you need to start questioning what you're sharing or what you're receiving as information in the forums. So, we know that it's really misguided. I mean, especially the PR related stuff. I mean, I've seen so many different documents that folks have shared with me from, filings that they've done with other attorneys and such, and they're getting destroyed. I mean, they're not dumb. Like, just because you have a picture of yourself in a, magazine or whatever, and it's PR. They could sense that, and adjudicators are very smart about this. So I think it's really important to understand that you're in a situation where you need to provide good evidence. I mean, I, for example, see folks who earlier today, for example, I met a very highly professional, upper level, like, product related professional who, his salary, for example, if your salary is in the range of close to $500,000, I don't want you to go and start dealing with a bunch of BS PR related campaigns. It's not going to help your case. It's just completely unnecessary, and unfortunately going to ultimately be detrimental to the ability of your petition to be approved. You're undermining the credibility of your other evidence by submitting things that really, really don't matter and will not result in any kind of approval.
So, I mean, it's great, Sharif, that you mentioned that. So basically, one of the things that I've also been seeing, right? Of course, we are very grateful that many of our clients now, many of the people who want to sign up, have been recommended by previously like happy and successful clients. Although we do see, but a handful of people, our clients actually, who how do I say it the right way? Who filed with different attorneys, and then for some reason maybe the attorneys are not able to handle the RFE, so they come to us instead. So what is your take on that? How come there's more and more people, especially from other firms, having RFEs, and maybe how can they best optimize your EB-1A cases? Not necessarily to like just avoid RFEs, but what's your take on that in general, especially for EB-1A clients?
Yeah, I think that there's again a lot of people jumping on an EB-1A bandwagon where you need to understand that it's EB-1A is really about a specified area of endeavor. So the way that you have an EB-1A approved, and often the first thing I ask people when they are working on an EB-1A case and maybe they're not making enough progress, or they're coming to us from a different avenue, is like, what is your field of endeavor, or what is your specified area of endeavor? And 9 times out of 10 they don't know, and that's a big red flag. That means that they are not following the proper strategy to actually get their case approved. EB-1A, first and foremost, is all about demonstrating that you are well established and that you are of very high repute within a specified area of endeavor. So if you don't know what your specified area of endeavor is, then that's going to be a big red flag. And I would say that's the first thing that one should ask himself or herself is, what is my specified area for which I am seeking classification as an individual of extraordinary ability? I'll repeat the question. What is my specified area where I am seeking classification as an individual of extraordinary ability? If you have not asked yourself that question, then you're not on the right track. So you need to make sure that you have a specified area that is well thought out and matches the past contributions that you have been, responsible for. So that would be the probably most important piece to this, is to make sure that you have this specified area of endeavor for which you are responsible. And then I think probably the second reason would be what I had mentioned before with regard to, not having evidence that is deemed credible because it's based on PR, and that sort of thing is not going to fly, particularly if you're relying on it. Like, at the end of the day, you have to think about a situation where if you're applying for an EB-1A category, you need to kind of play it to your strengths. So if you are a business related contributor who's applying for EB-1A, then you need to focus your case on business related contributions that you've made. I mean, I know it sounds very simple, but some people don't do this. Like, if you're, for example, one who is, I mentioned, a product creator, a product manager, if you will, somebody who's, seeking to develop products from concept to delivery, then you're not going to get an EB-1A approved because you published an article. All right. So if you're conceptualizing, developing, and ultimately delivering a product, that needs to be the centerpiece of your case, that you are responsible for developing and essentially delivering this product into the marketplace is going to be the basis for your approval. So that should be the most important reason. Now, there are situations where folks get an RFE and it's just a fair RFE, or maybe it's an adjudicator who didn't quite process or all the evidence, right? Because either there was a misunderstanding from the adjudicator's perspective, they needed further clarification. That's fine. Like, an RFE is not the end of the world. An RFE is just simply a situation where they're asking for more evidence. It's not a denial, right? You can actually get a worse thing, which is a notice of intent to deny. So, sometimes I tell people who come to me because they got an RFE, even if it's with another attorney, is like, look, I think that you're actually pretty close to approval. It looks like, there's just a few things that need to be adjusted. And, I think for the most part, the case looks decent. So you might not need to shift gears in that scenario, but there are times, and, so sometimes people ask it takes too long for the attorney to get back to me or something like that. I mean, folks have big caseloads. I mean, we have a very difficult caseload. We're not always going to immediately respond to everybody. It's going to take time. What's more important, in my view, is what is the result? What is the end product? What is the like overall situation? Have we done the absolute maximum to get this case approved? And if we've done that, then I feel like we've really hit the metrics, and 9 times out of 10, that case is going to be approved, where you don't leave anything out on the field. I mean, if I take a case and I feel like this person understood our strategy and we really jived in terms of like connecting and, developing a really good case, then, those cases I think would, I would say not just most of the time, but, again, like 9 times out of 10 those cases will be approved, even if we have to go through an RFE because the government needs a particular kind of clarification or argument or what have you. Then that's definitely, something that we can overcome.
Yes. And I just wanted to stress that, I'm very proud that like what Attorney Sharif said, right? Like RFEs are not, the end of the world. In fact, we've proven we have so many happy clients, many of them even coming from different attorneys, and we were able to overcome and obtain an approval for them. So I'm very grateful to people who've, written a lot about what we have done for them. And so again, because again, we have so many people inquiring about our EB-1A services, and many of them, like what you mentioned a while ago, Sharif, many of them really rely on forums, right? Especially many of our friends who are Indian nationals. And it's hard, to sometimes believe, take it as like gospel truth, right? Like a Quran, basically. So I think what I have to stress there is that, you cannot just rely on one channel of information, right? And in most cases, it's tough for me, when it comes to helping Sharif, it's tough for me when people say, no, but, they compare with people. No, but this guy in this forum, this guy I met in this group, my friend so-and-so, they think every case is the same. And so that's why we have to underscore, and underline really that, again, Silmi law is all about, creating a very unique case for each and every one of you. Like, for instance, Sharif, maybe we can explain the difference, because some clients, admittedly, they come to us, with a very strong profile. They even avail of our white glove package, right? Which enables us to, finish their cases in a more prioritized time frame. Whereas there are others who still come to us and they're very happy and we were able to drive success for them, but not necessarily within, a white glove time frame. So maybe, Sharif, you can maybe share for the benefit of many of our friends, because some of them, they know, that they admittedly come with maybe 1, 2, 3 evidence, right? Maybe not enough to satisfy the minimum 3 criteria. But just so, we can maybe differentiate the levels of readiness, especially when, it comes to really getting our services. Because we do help, building clients' profiles as well, helping them through the very long, and possibly tough EB-1A process.
I think it's really all about what area or what vertical the person is coming from. So like a case for one who is a business related contributor, technology related contributor, is going to be very different than one who's a scholarly related contributor. So somebody who's in academia or research, those cases are going to be different than technology cases or engineering cases and such. And then you have education related cases, which are a very narrow niche. And then definitely athletes and artists are just a whole different story. So basically every kind of vertical is going to have big differences. And then within those verticals, you're going to have, different strategies and approaches. And that's why I think the most important thing is to understand that you have to take a uniquely tailored approach to get your case approved. This kind of one size fits all narrative, I don't think is going to be productive. It's going to result, in basically, a lack of optimization for one's profile. So I find that, every case needs to have a uniquely tailored approach. Now, when you look at a uniquely tailored approach, you're going to, I personally feel like the things that the individual has done for as their career is always going to be the most important thing. So when you're thinking about an EB-1A case, because an EB-1A case is the bottom line is what you're trying to prove is that you are among a small percentage of professionals who have reached the very highest level of a specified field of endeavor. That's the ultimate goal, right? So if you're among a small number of small percentage of individuals or professionals who have reached the very highest level of your field, then that's usually going to be based on what your career has been. So your career is basically, again, the vast majority of individuals going to be something that you've done in the scope of employment. So therefore, my view of it is that we should sort of mine your case for your career related achievements rather than, and then so combination career related achievements and salary. I would say so that sort of is the fundamental of the case. So if you have those present, then you basically have the fundamentals, right? And then once you have the fundamentals, because if you think about it, career related achievements are going to fall within critical role for organization, distinguished reputation, original business technology related contribution to major significance, or if it's a scholar, original scholarly related contributions, major significance, educator, original educator related contribution, major significance, et cetera, et cetera. And then salary is sort of like coming in with them. So that's 3 regulatory criteria right there based on your career, right?
And stress that, of course, it will make sense for me to continue in the same field, which is another important. I'm not suddenly shift to a different field when I've reached the top in my current field.
Exactly. That's your specified area. Those are the 3 that are, so that like, but if you're an artist, for example, right, there's a lot of artists out there. We love artist cases. I like literally that would, to me, these folks are, contributing culturally in a major way that's helpful, and they deserve also to have good representation. So if you're an artist, probably the more important regulatory factor is going to be that you have your artwork has been showcased or displayed in an artistic exhibition. And then the question becomes, was it sort of like reviewed by critics? And, how did that go? Right. So like, it's a completely different sort of approach that you're going to be taking in terms of demonstrating what your stature is within your field. So just going back to the business or technology or maybe engineer, their case is going to be based on what they've actually done throughout the span of their career and what sort of compensation they've received for it. That's the fundamental argument. Then you have a supplemental argument. So a supplemental argument might be, I've also been invited to review and judge the work of others. I've also been invited, or I've been participant in a professional organization that required outstanding achievement of my members or of its members, or I've maybe published a trade publication or scholarly article as an outgrowth of my sort of stature within my profession. Not that that's the central argument to make, like it would be if I was a scholarly related contributor. So again, I mean, I think all of these factors are really just, they change according to, what the needs are. And now the lawnmower's outside my window. So maybe it's a sign that we're needing to wrap up soon.
Okay, so basically, yeah, fundamental and supplemental. I think that's a first good thing to ponder on. And one more question, Sharif. One last before we go. So basically, yeah. So most people focus on the criteria, right? They need to hit and satisfy at least 3 of the 10 criteria. But then some of the people are asking as well, like, how do we help them on the second part, right? Because I think you're very clear in all of our videos that it's not just 3 criteria, at least 3, right? But there's the second part. So I mean, how
final merits determination.
Yes.
And the final merits determination, you need to understand that the regulatory criteria are a vehicle that you use to reach the destination of establishing the final merits determination that you are among the top percentage of experts within your specified area of endeavor. So for example, if you are in a, particularly, and that's why I think for a business or technology contributor, original contribution and major significance is so important, because the idea here is compartmentalizing originality and significance. So significance is what is the significance of the contribution I've made to the area or in specified area of endeavor that I'm a part of. And that is basically judged by how well is it recognized by those who are outside of my circle of professional acquaintances. So those who have never worked with me, those who are within the field but have, are not at my company, those opinions, whether it's in the media or whether it's, basically testimonial, or whether it's, for example, in a industry type document, like a Gartner report, for example,
Mhm.
that view of the product or contribution I have made will determine its significance. And that is the vehicle, that is the importance of what I've done to the field. Therefore, the one who's responsible for developing that contribution can only be deemed to be at the very highest level of his or her field. That's what final determination is all about. It's about using the criteria to prove that I'm among a very elite top percentage of professionals within my specific area of endeavor.
And that is what your case will be built on. So I
Absolutely.
think that's it, Sharif. So we have a lot of clients to return to, and you have your things. So thank you very much, Sharif. We're very grateful, and maybe like final message to everybody before we hop back to our calls and clients.
All right. Thank you, guys. Thanks, everyone. Take care.
Thank you, and we'll see you in our next videos.
Bye-bye.
Take care. Thank you, Sharif.
Bye-bye.